Welcome back to Oral Arguments and Opinions. Today we'll discuss the June 12th, 2025 Supreme Court opinion in the case called Rivers versus Guerrero, case number 23-1345. We'll first walk through the syllabus, discuss a couple case implications, and compare how the oral argument transcript fared against the opinion. Please note that this summary is read by an automated voice. The question presented in this case is whether Section 2244b2 applies 1. Only to habeas filings made after a prisoner has exhausted appellate review of his first petition, 2. To all second-in-time habeas filings after final judgment, or 3. To some second-in-time filings, depending on a prisoner's success on appeal or ability to satisfy a 7-factor test. Justice Jackson delivered the opinion for a unanimous court.
Justice Jackson's unanimous opinion. Petitioner Danny Rivers was convicted in Texas State Court of continuous sexual abuse of a child and related charges. After unsuccessfully seeking direct appeal and state habeas relief, Rivers filed his first federal habeas petition under 28 U.S.C. Section 225(4) in August 2017, asserting claims of prosecutorial misconduct, ineffective assistance of counsel, and other constitutional violations. The district court denied the petition in September 2018, and Rivers appealed to the Fifth Circuit, which granted a certificate of appealability on his ineffective assistance claim in July 2020. While his appeal was pending, Rivers obtained his trial counsel's client file, which contained a state investigator's report that he believed was exculpatory. After the Fifth Circuit denied his request to supplement the record on appeal, Rivers filed a second Section 2254 petition in the district court based on this newly discovered evidence. The district court classified this second-in-time filing as a second or successive habeas application under Section 2244B and transferred it to the Fifth Circuit for authorization to file. Rivers appealed the transfer order, and the Fifth Circuit affirmed, holding that the fact that Rivers's first petition was still on appeal did not permit him to circumvent the requirements for successive petitions under Section 2244 as to his second filing. Held, once a district court enters its judgment with respect to a first filed habeas petition, a second-in-time filing qualifies as a second or successive application properly subject to the requirements of Section 2244B. A. The Anti-Terrorism and Effective Death Penalty Act of 1996, AEDPA, contains several significant procedural barriers that strictly limit a court's ability to hear claims presented in any second or successive habeas corpus application. Relevant here, Section 2244 prohibits habeas applicants from filing a subsequent petition that relitigates the merits of previously denied claims. Even if the subsequent petition presents a new claim, the second-in-time application can only proceed if it relies on a new and retroactive rule of constitutional law, or alleges previously undiscoverable facts that would establish the petitioner's innocence. In addition, a petitioner cannot bring a second or successive habeas application directly to the district court, but must first go to the Court of Appeals and make a prima facie showing that the petition satisfies one of Section 2244B2's exceptions. B. The court has jurisdiction to review this dispute. Respondent contends that Rivers lacks standing because the Fifth Circuit has now affirmed the district court's judgment denying the initial habeas petition on the merits. But because a favorable decision here would redress Rivers's alleged injury, that the district court inappropriately transferred his second habeas application to the Fifth Circuit for review under Section 2244B, Rivers has appellate standing with respect to that legal claim. Nor does the fact that Rivers is no longer in custody on the child pornography conviction that his second habeas filing challenges defeat this court's habeas jurisdiction, given that Rivers remains incarcerated on related sexual abuse sentences that the newly discovered evidence may implicate. C. The phrase second or successive habeas corpus application in Section 2244B2 is a term of art that does not refer to all habeas filings made second in time following an initial application. Whether a filing qualifies as a second or successive application generally turns on the existence of a final judgment with respect to the first petition, not the status of any appeal. An amended petition filed before judgment is not second or successive because final judgment has not issued, while a motion under Federal Rule of Civil Procedure 60B filed after judgment counts as a second or successive application if it attacks the court's previous resolution of a claim on the merits or seeks to add new grounds for relief. Rivers's argument that his second filing should not trigger Section 2244B because his appeal was pending is unpersuasive. The court's decision in Banister versus Davis, 590 U.S. 504, does not support a rule that is based on appeal timing, but rather confirms that entry of final judgment generally separates first from second or successive habeas filings. Rule 59E motions present a unique variant because they suspend finality and help produce a single final judgment, but Rivers's filing does not fall within this narrow category. D. Purpose and history do not support Rivers's interpretation either. Section 2244B's restrictions aim to conserve judicial resources, reduce piecemeal litigation, and lend finality to state court judgments within a reasonable time. Drawing the second or successive line at the end of appellate review would allow petitioners to file numerous new applications during appeals, prolonging cases and encouraging piecemeal litigation. Historical habeas doctrine before ADPA was inconsistent regarding treatment of new filings during pending appeals, providing no clear guidance. E. The court declines to address Rivers's alternative argument that his second filing, which he argues was a Rule 15 motion to amend, is not a new application by its nature. This theory was not presented in the petition for certiorari or to the courts below, and makes its first appearance in the merits briefing. Additionally, the factual predicate is lacking because the district court lacked jurisdiction to grant such a motion while the case was on appeal, and Rivers never requested an indicative ruling under Rule 62.1. Affirmed.
Case implications. First, this decision creates a clear, bright-line rule for federal prisoners and their attorneys. Once a district court enters a final judgment denying your habeas petition, any new filing you make, even while your appeal is still pending, will be treated as a second or successive petition under AEDPA's strict gatekeeping requirements. This means you can't simply file new claims or present newly discovered evidence directly with the district court anymore. Instead, you'll have to go through the much more difficult process of getting permission from the Court of Appeals first, and you'll need to meet AEDPA's extremely narrow exceptions, either showing your claim relies on a new retroactive constitutional rule or that you have previously undiscoverable evidence that actually proves your innocence by clear and convincing evidence. For most prisoners, these exceptions are nearly impossible to satisfy. Second, this ruling significantly impacts litigation strategy for habeas attorneys. The decision essentially forces lawyers to be much more thorough and aggressive in their initial habeas petition, because they now know that once that district court judgment comes down, their options become severely limited. This creates pressure to conduct extensive pre-filing investigation, to include every possible claim up front, and to think twice before appealing a denial if they believe new evidence might surface during the appellate process. The days of being able to supplement your case with new evidence during an ongoing appeal are over. The courthouse door effectively slams shut the moment that first judgment is entered, regardless of what's happening on appeal. Now, let's compare the oral argument to the opinion. What stood out most to me listening to this oral argument was how Justice Jackson basically wrote her eventual opinion right there during questioning. After Justice Thomas finished his opening exchange with Rivers's lawyer, Jackson jumped in with pointed questions, and you can literally hear her working through the exact reasoning that would become the court's unanimous decision. Here's what I mean. Jackson hammered on this idea of the work of the judgment. Basically, when does a court decision actually matter for determining what happens next? She's asking, once a judge bangs the gavel and says petition denied, why should it matter that your appeal is still going on upstairs? That became the heart of her written opinion. The court said the moment of judgment is what counts, not whether your case is still bouncing around the appeals process. Now what's fascinating is that the oral argument revealed justices working through different concerns before reaching unanimity. Justice Gorsuch seemed sympathetic to Texas's position, basically saying, you can't just file new stuff willy-nilly once your case goes up on appeal. Justice Sotomayor was drilling down on procedural technicalities about what Rivers should have done differently. Here's another tidbit. Justice Alito zeroed in on what he saw as a troubling trend: lawyers changing their argument between the petition stage and the actual argument. During argument, Justice Alito said the Supreme Court has had a mini epidemic of cert petitions that have convinced us to take a case because there's supposedly a conflict on a certain issue. And then once cert is granted, the argument that is advanced by the petitioners, quite a bit different from what we were sold at the petition stage. He bluntly asked whether this was another outbreak of the same disease. Justice Alito took issue with the fact that Rivers got the court's attention by framing this as a timing question. When exactly do AEDPA's strict rules kick in? But then at oral argument, his lawyer started pushing this completely different theory, that his filing wasn't really a new petition at all, but just an amendment to his original case under Rule 15 of Civil Procedure. Think of it like this. Rivers initially said, "The timing is wrong for applying these strict rules because my appeal was still pending." But then he shifted to, "Actually, this shouldn't be subject to those rules at all, because I was just trying to amend my original petition, not file a new one." Justice Alito suggested that this was a fundamentally different legal argument. While the final opinion did address this Rule 15 amendment argument, Jackson's written response was much more measured and technical than Alito's oral argument frustration suggested it might be. The court methodically explained why the argument failed, both because it wasn't raised below and because Rivers never actually followed the proper procedures for amending during an appeal. What really drove the unanimous result was this: even justices who seemed concerned about harsh consequences for prisoners couldn't figure out how to make the law work in Rivers' favor. When you hear the lawyers and justices all struggling with the same statutory constraints during oral argument, that can indicate the case is heading for unanimity. Not necessarily because everyone's thrilled about it, but because the law is just too clear to interpret any other way. That's a wrap on Rivers versus Guerrero. Stick around, we've got 5 more opinions from today's decision day coming up. Hope you enjoyed this episode. If so, please follow, share, and review.